Good morning, Chattanooga. This is our first show in the month of September, so welcome all. There's a feeling of fall in the air, and it feels pretty great out there, actually. With us today is Katie McGregor, an attorney with McComb, Williams, Ashley, and Stanley. How are you doing, Katie?
I'm doing well. How are you, Jim?
I'm fine, thank you. Did you enjoy your morning that feels brisk and fall?
I know it is really nice out. I like the cooler weather.
It is, and they say it's going to stay with us for the rest of the week, so that's a wonderful thing. And today, Katie, you're with us today because one of the things I wanted to talk about and I wanted to share with our listeners is environmental redevelopment of properties in the Chattanooga area and things that people should consider, whether it's in Chattanooga or any area of the United States, with respect to possible redevelopment. But before we get into that, I wanted to talk with you, the listener, about the show. You know, we started Legal Bytes as a show in December of 2016. So we're now, I guess, been 9 months doing the show. And we've covered a lot of topics. Every week we try to basically provide some type of service to the listeners with respect to information that they can use. And as we put it, in their personal lives, with their families, or in their businesses, with respect to legal issues that they're going to have to address. And we've talked about estate planning. We've talked about powers of attorney. We've talked about criminal issues and the drug enforcement crimes. And we've talked about the cyber crimes and the rights and causes of actions individuals may have as a result of having their computers accessed inappropriately and without authority. We've talked about property issues and the development of property and contracts. And in fact, we've gotten into some car accidents and tort issues and the like. So we've a huge gambit of topics. But I need to know what you, the listener, would like to hear about. I mean, and I've forgotten, we've talked about juvenile courts and child custody matters and child support. I mean, truly, we've tried to cover anything and everything that might touch the listeners' lives, their businesses. There was a couple of weeks ago, we did a show, and one of the topics in the course of the show was embezzlement and how to protect yourselves from actions by employees and the like. And I know, Katie, you've participated in some of these shows and helped us, especially in the state area and the real estate area. You've talked about issues and the like. I've really appreciated your expertise in those areas, but I'm just not sure what the listeners may want to know. So if you have any thoughts that you want to share with us or topics, 423-800-8949. That's 423-800-8949. And we'll be happy to discuss areas that you'd like to try to bring in. And maybe even if it's a broad topic, set up a special show just for you to talk about those areas for the public. And because I'm sure if it interests you, the listener, it interests more than just you. And there's several people in this community that would have interest in it. So I'm opening that up to you at this point in time to let you know that you can call in and share with us what you'd like to hear about. Because I know that, you know, what we as lawyers may find interesting just because of conversations with my wife, the normal people, as she puts it, find it very boring or mundane and cannot stand the conversation. She doesn't care about res judicata or collateral estoppel or what happens in a motion for summary judgment. I mean, those are things that just really don't pique her interest, and I'm sure it doesn't pique the interest of the community at large. So I know, Katie, you and your husband probably have talked about some of the things that you do, and he doesn't find them very interesting either.
Yeah, I think he kind of tunes some things out.
Yes.
I find it fascinating. He's like,
I mean, it's hard to, and the worst thing I get is I get into a conversation with my wife, and she'll say, "Quit cross-examining me." You know,
that's pretty bad, Jim.
I mean, you know, she'll say something and I'll start asking details about it. And she'll say, "Look, this was a conversation. I'm not in a deposition. Stop this." So, and lawyers, we aren't by and large normal, I guess, because of what we do. And I mean, and we do so many varied things. I mean, for example, today, in fact, I was meeting with detectives down at the police service center on a case. And yesterday I was meeting with some physicians on a matter. So, I mean, we have such a varied scope of what we end up doing. And we have to know little details that it comes up. Hold on a second, we have a call coming in. This is Legal Bytes caller. You're on the air.
Hey, Jim, Mike Steele. You're tied with David Tulis as my favorite show on the radio. I love hearing talk of the law. And, I wish people would become more interested because we're all legal persons. And let me tell you, I'm so proud when our republic and our Constitution works. The Gaddies filed a petition for writ of habeas corpus, and David helped with the federal petition for writ of habeas corpus. And they listened. She was brought before the judge, and they listened and freed her. And this is where the individual has power over the state. And I'd like your opinion on this, too. I love the story of the Philadelphia lawyer. And I tell people never, ever, ever try to evade jury duty, because you as that single juror are the most powerful person in the world, that person sitting in the defense chair, that you can rule not guilty, even if you think that they violated the law. You could say the law was not a good law, even though the facts have shown that you have violated the law. We think it's unjust, not guilty. And they walked free. And I love that about our system. I love that check and balance.
Well, you're right. There are some checks and balances. Do you want to stay on the air with us, caller?
Sure.
Okay. Well, yeah, there are checks and balances in the system, and the public, in the jury, and serving jury duty is one of the greatest responsibilities. I agree with you that we as citizens have. I don't necessarily agree that it's the function of the jury to determine that they think a law is unjust and so they're not going to apply it. I think that happens. I think that happens in the course of jury deliberation. I think people have their own opinions with respect to whether a law is fair or unfair. But it's my opinion.
I respectfully disagree with you on that, because in studying the founders, they were adamant about the jury having the final say over the law. And I'll give you an example when I cover trials. There is no law under Title 26 that requires anyone to file a tax return. However, there is a law of willful failure to file. And I've covered these trials where the prosecutor will stand up and say, they didn't pay their fair share and the law says they didn't file. But yet they never reveal that there is no law requiring it. And this is where the jury needs to step in, and that's why they can't get a conviction in Montana. To say, where's the law?
Well, I understand, but the jury's purview, in my opinion, is to apply the law as it is given to them, to the proof that they've heard, and determine how the law applies and what the facts are. I don't agree that the jury should be deciding whether the law should be changed. That has never, in my opinion, been the function of a jury. But you and I disagree.
Well, I love the Philadelphia lawyer. I love the story of the Philadelphia lawyer, and that's where jury nullification or lawlessness comes in. But in the case of the writ of habeas corpus, it actually worked, and she's free because of that. So
right, and it
shows where the system did work.
Right, and it does. It works every day. It just doesn't make the news, but our system works every day. What's that saying? Democracy is the best, worst system.
It is.
It's the best we have.
All right. Thank you. Thank you for the show.
All right. Thank you for the call.
Bye.
All right. Well, that was an interesting call, and I agree. And maybe that's one of the things that we should talk about more in future shows is the constitutionality of the various systems that are out there and how our system works, and maybe even have sort of an 8th grade civics class.
I think that would be really interesting. This weekend I was in Virginia and outside Charlottesville, and I actually visited Montpelier, James Madison's home.
Mm-hmm.
And it was really interesting. I learned so much, and all that he spent so much time studying all these different governments to work on our Constitution. So
Right.
it was really, really interesting.
And it's interesting. We were both in Virginia. I didn't know. I was just down the road at Washington Lee in Lexington, Virginia.
Oh, I didn't realize you were there too.
Yes, I was up there all weekend. Came back Sunday, but in fact, the interesting joke going on right now is that Washington and Lee can no longer be called Washington and Lee because of Robert E. Lee. It was named after him because he was the president of the university right after the Civil War ended. He
Mhm.
went and took the position and stayed there till 1870 when he passed away. So he was the president of the university 5 years, but really turned the curriculum and the expanse and the approach of the university around and to what it is today. And then, of course, George Washington owned slaves, fought Indians, and fought the French. And so now they're saying that it may just have to be called the university.
Really interesting.
So, but anyway, so yeah, I agree. There's so much in the state of Virginia with respect to the founding of our democracy and what's out there. It's truly a wonderful trip if you ever get a chance to go to some of those places and see what's out there.
It is.
So, but anyway, that's something we can talk about is the approach with respect to the constitutional issues. All right, hold on a second. We have a call. Yes, caller, you're on the air.
I had a question about a piece of property I'm concerned about. I'm trying to find out about remedies or what kind of a legal action I might have for underground storage tank that's on the property.
Okay. All right. So let me get a little more detail. How long have you owned the property?
We've owned it about 3 years now, and there wasn't a lot of disclosure from the previous owner. They didn't tell us what was kept in the tank. Finding out now there may be a leak in it, and trying to find out if there's a way I can go back and get some help from that previous owner.
All right. So you knew that there was a tank out there. You just didn't know the contents of it.
Yeah, I didn't know the condition of the tank, didn't know the contents. They did indicate there was a tank on the property previously.
Okay. All right. Well, do you want to stay on the air by our caller, or do you want to discuss it with y'all?
Well, whatever you
All right.
you think.
Well, I'll just tell you that if it's commercial property where there's not a disclosure requirement, unless there are representations in your contract. Now, if you've got reps and warranties in your contract with respect to the UST or an underground storage tank, then you may be able to bring an action under your contract for fraud or breach. But if the reps and warranties are very vague and there was a disclosure to what's there, then I think the law is going to put it on you because basically you had an obligation, and the better approach is for you to do both a phase 1 and possibly a phase 2 investigation with respect to the property. Go to the state, see what you can find out about the prior UST, because it was probably registered when it was put in years ago. And the phase 1 will give you information about the prior uses of the property and the like. And if you didn't do that, but you had knowledge of the UST, then you may, absent something in your contracts, you may have the responsibility of what you bought. And agreed, it may be a pig in a poke from that standpoint for you, but unfortunately, that's the way our environmental approach has been. Is that you had a duty to investigate once you knew there was a UST out there.
Okay, I appreciate you helping me.
All right. Well, I'm sorry. I've got to tell you what you need to know. All right. Thank you.
Okay. Thank you. All right.
And that's one of the areas that we were going to talk about today, actually. And that caller sort of set us up is the redevelopment in Chattanooga. There was a wonderful article back on the 17th of August in the business section of our local paper with respect to the redevelopment of the U.S. Pipe and Wheeling Foundry sites and the studies that are going there. Chattanooga is very blessed to have a lot of good people who are interested in the future of Chattanooga. And I know Gary Chazen and Mike Mallon personally, and they're both really knowledgeable and invested in the community and want to do the right thing and have been spending time through their groups. They acquired part of the Wheel and Foundry site out of bankruptcy. They purchased through separate entities the U.S. Pipe properties and have been working diligently to not only investigate and try to address those properties, but also look at the best future redevelopment of those properties for Chattanooga. And that's what that article was about, was one considered redevelopment approach is to put in basically a SunTrust Park on a mini level, like Atlanta's done, and that is to move the lookouts and set up a new stadium there right in what a lot of people call the gateway to Chattanooga, coming down interstate from Nashville. I don't know if you got the chance to read the article, Katie, but
unfortunately I didn't. But
yeah, they're talking about putting right there as you come down I-24 and you go into that bend where U.S. Pipe used to operate, and put in a stadium, and then have mixed use redevelopment around it with retail, with restaurants and stores, and then having some maybe hotel properties for the tourism that will be in that area, and then to have homes and condominiums and have a mixed development there, right there in the gateway that would not only certainly beautify that area as you come into Chattanooga and see the beautiful new stadium that they're conceptualizing and the like, but also would add thousands and thousands of dollars to tax base, and would also create that part of Chattanooga as a destination, 365, because with the mixed use, you'd not only go there for baseball.
right. I mean, if you're coming, they've got restaurants and shopping. There's a lot that would be there other than just a game.
You and I'd be running over there for lunch.
That's right.
So, I mean, that's one of the things, and you're seeing that all over Chattanooga. It's, that's part of what the South Side development's about. That's part of what Riverfront was about. And you're seeing it. And so when you're looking, because Chattanooga's industrial history, it's hard to find a piece of property that doesn't have some foundry sand on it, that, where it was used for fill dirt because no one knew in the past. I mean, Chattanooga, in fact, as a lot of cities, PCBs, which are in transformer oil. PCBs, when they would drain the transformers, and that oil, PCB laden oil, would be used to coat asphalt streets. I mean, people did not know in the pre-60s era, and all through the 60s, they did not know, the ramifications of what was being used, such as foundry sand and the like. And so as a result, we've got properties in Chattanooga that have some contamination on them that may not have been industrially used, but simply because of development, even of residential areas, where they were trying to raise the property up the levels of the property, so they brought in soil that was contaminated. So, I mean, that's something that we're lucky here in Chattanooga. We have a field office for the Tennessee Department of Environment and Conservation, TDEC for short, and have some really good people over there that are involved in helping Chattanooga redevelop. One of the people that I work a lot with is a gentleman by the name of Troy Keith, and he's very user-friendly, very interested in trying to make sure that Chattanooga moves forward and we see properties redeveloped, but still making sure that we do the things that protect the health and safety of the community and follow the environmental regulations. So we're very blessed to have that type of individual here working with us. And
so, Jim, what types of process does someone that's going to redevelop this property, like in the U.S. Pipe and Wheel and Foundry sites, what kind of process do they have to go through in order to get it to the point where it's a stadium?
Well, I think I'd start with acquisition, and just as we had the caller here that called and said he's got a UST that he knew about, or underground storage tank, excuse my acronym, he knew he had an underground storage tank on his property. It was never clear what it was used for. Thinks it may have been leaking, and now wants to know what rights he has back against the seller. And with him having knowledge and conducted no investigation, unless there's something in his contract regarding reps and warranties made by the seller with respect to the to the UST and its condition, use, etc., then he probably doesn't have rights because it was knowledge he had. So, but getting back into an acquisition, you've got to do some due diligence and some investigation with respect to any potential real estate that you're acquiring. I'll give you an example. I've got some clients who were purchasing a church to redevelop, and in the course of the acquisition, had what's called a phase one investigation done, environmental report. And phase one is a non-invasive environmental investigation where what it entails basically is you have a professional, environmental professional go out and they'll do a site inspection. You look at the property. What does the property look like? Can you see any remnants of prior use? Can you see any areas that appear that, the soils don't look right? So it's all an observation. And then you do some investigation, not only of the history of that piece of property, but you also do investigation of adjoining property and uses so that you can determine whether or not that there's a potential that even if there wasn't any activity on the property you're looking at that could have been would cause contamination, you have adjacent properties that could have contaminated it because of, and we call it lithography. It's basically the structure of the subsurface and the flow of groundwater subsurface, and could contaminants that may have gotten on adjacent property flowed under your property to have affected it. So, we do all that type of investigation. And with respect to the church, it was discovered that from about 1940 to about 1963, there was a filling station on the same property that the church used to exist in.
Okay. So you've discovered this filling station. Was that before the purchase of the property?
Yes.
Or okay,
it was part of the phase one. So we're doing a phase one, and phase one is non-invasive. It does not require really any authority or permission from the seller. So you as a potential buyer can do a phase one because you're not doing an invasive investigation on the property. You're merely looking at the property, doing a walkthrough basically, and then you're also doing background investigation. I mean, there are flyover photos at TVA where you can see what may have happened at the property over various periods of time, going back years because of the flyovers. You can pull tax records and business licenses and the like for that piece of property, and you can determine what all occurred over many years back. Okay,
so this phase one came back that there was some type of contamination, or not that there was, but there was a possibility.
Sure,
because of the activity.
Right. And we know just because of logic that if there was a filling station there would have been underground storage tanks there. And because of the time that it ceased activity, the issue comes up. Okay, well, if it stopped in the early 60s, it's before we had the UST program.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM. 3, 2, 1. Chattanooga Radio, AM 1240 and 92.7 FM's news now.
Living in Chattanooga is going to get a little bit more expensive. The city council voted 8-1 on a 22-cent property tax increase above the certified rate. They also voted on the senior tax freeze program, voting positively for the mayor's new budget for fiscal year 2018. The only city council person to vote no is the chairman of the budget committee, Chip Henderson, casting the only no vote. The city budget also includes an increase in pay for city employees, including police officers, and a new gun crimes unit for the CPD. What are the odds of this? A woman was driving her Honda Pilot down Hickson Pike right near Stewart Heights Baptist Church when a tree fell down and crumpled her car in the storms yesterday afternoon. The SUV was completely totaled, but the woman driving it got out unharmed. The Chattanooga Fire Department was on scene to assist. Russell Stroud, Nooga Radio News Talk 92.7. Now.
In-depth traffic, news, and information. Mornings on Nooga Radio, AM 1240 and 92.7 FM.
Nooga Radio News Talk 92.7's fast forecast now. 82 for our temperature for our mid-afternoon. Expecting heavy thunderstorms to roll through our area, lasting all afternoon and overnight into Wednesday morning, where 75 will be the high and 52 the low. Expecting the rain to taper off Wednesday morning, and it should be clear by mid-afternoon tomorrow. Through the rest of our week, highs in the mid to upper 70s, then by Saturday, 80 degrees. That's your fast forecast now.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
You've been in a wreck.
756-6400.
You've been wrongfully fired.
756-6400.
A turkey is suing you out of the blue.
756-6400.
Confused about a business startup?
756-6400.
That's the number for you. 756-6400. Right here, right now, Chattanooga. Call now. Top flight legal help awaits. Get biz advice now. Representation to fight for your right. What are you waiting for? That's 756-6400. Don't sit on your rights. You've got remedies. Turn your tragedy into cash. You've got the solution from estate planning all the way to probate. Act now. Top attorneys in Chattanooga are waiting to help you get relief. Act now. No out of pocket. You don't pay a dime until we win. So win with us.
756-6400.
Call now. Top flight legal help awaits. What are you waiting for? That's 756-6400. Turn your tragedy into cash. Act now. No out of pocket. You don't pay a dime until we win. So win with us.
756-6400.
756-6400.
Nooga Radio, AM 1240 and 92.7 FM knows your opinion is important. So call 800-8949. Agree or disagree. Call 423-800-8949. 800-8949. Nooga Radio, AM 1240, 92.7 FM, and 95.3 HD4. News, talk, sports. Nooga Radio. The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
Welcome back to Legal Bytes. This is your host, Jim McCoon. I'm here with Katie McGregor. And I was so gracious in the way I ended the last half hour. I was in the middle of discussing our topic and the issues with respect to environmental investigation. And I lost track of time. I'm embarrassed the way I was surprised, and I was running out of time because of the stop. So I apologize to the listeners that heard that. They was just terrible.
You were telling us about some work that you've done on a church property.
Well, and it doesn't have to be a church, but this one happened to me. But any property, the phase one will show you the history of the site, or should show you the history of the site. Hold on a second, we got a call. Yes, caller, you're on the line. This is Legal Bytes.
Yes. So I just had a quick question. I've been wondering, there's a viral video right now of a nurse getting arrested at the ER. A cop had asked her to take blood from an unconscious person that was in police custody, and she refused to do it because it was against hospital policy. And she ended up getting arrested for refusing to draw blood. The cop said it was obstruction of justice or something like that. And he was really rough when he was arresting her. So a lot of people are really angry about this, and I was wondering, does the nurse have any recourse against the cop or the police for wrongful arrest, or I don't know, something like that?
Well, certainly she might. Not being involved, and I haven't seen the video, but yes, certainly she may have some rights, both from the standpoint of a wrongful arrest or deprivation of her rights, Fourth Amendment rights with respect to a seizure of the person. So you get into, do you have a 1983 claim under federal law, which would prevent you from having your constitutional rights, including the Fourth Amendment, violated? She may have claims under state law. She might also have malicious prosecution claims if the criminal matter is dismissed. There's a myriad of potential claims that she would have. All depending upon, how all that comes out. Again, I've not seen the viral video, but it sounds terrible that an officer would arrest her because she was complying with both hospital policy, because there hadn't been a consent given by the patient because the patient was unconscious. And so she was doing the right thing. and she didn't have any authority without that patient and without hospital authority to do what the police officer was asking her to do. It sounds like the officer was frustrated and was being stymied by what effectively are our personal rights. So, yes, I think there may be some claims that she would have, and that she should, in fact, and I'm sure she will pursue. So, but thank you. That's interesting. Again, those are things that I think we can talk about broader in future shows. These are the kind of issues that I'd like to hear from our community, is the things that they want to hear about and discuss with respect to. Whoops, we lost that. There, now cleared that up. But we talked at the very beginning of the show of wanting to hear from the listeners as to issues that were important to them, not necessarily what we've got online to talk about during a given show, like today with environmental and issues and the redevelopment of hampered property, but also talk about the areas that they want to discuss. And that's certainly a big issue. Is what are your rights if you're wrongfully arrested? And secondary issue is here where she's a professional and she's got to honor not only her employer's policies, but she has, because she's in the medical field, she has to honor the rights of the patient she's treating. And so she was really in a quagmire there as to what to do when she's got a police officer demanding that she pull a sample, and she's got no authority to do so, at least in her mind. And there may have been a statute that's in place that would have authorized it because of a DUI situation, like where the consent is already given by statute. I don't know what state. I've not seen the video, but certainly those are interesting issues.
They really are. There's a lot there to.
Yeah, I mean, a lot to look at, and both from a state cause of action and from a federal cause of action. So, but anyway, getting back to the issue, when you're doing your investigation, one can get the history of the site. In that particular situation, I was giving, it was a church that had previously, years and years ago, been a filling station. Well, by getting that information and by walking the property, you can at least estimate where the station, tanks would have been, and you have to determine whether they're still in the ground or not, and what was used for fill and the like. And so then you do further investigation. And we also all know, based upon what happens at filling stations, in the past, when it used to be they come out and fill for you, that there's something called overfill, and that's the spilling of petroleum products on the ground. They may either, if a person's filling their tank themselves, they may overfill and it comes outside the car and drips on the ground. They may pull out the hose quickly and there'll be some overspill. It just happens. And overspill over time can accumulate and cause contamination.
Okay. So after a potential buyer has received their phase one, and the phase one shows prior activity that
is of concern.
What happens next? Do they negotiate cleanup with the seller, or are they having to have more studies done before they purchase the property? What's the typical?
Well, you as the buyer with that information really would be hard pressed to go forward with the purchase without further information. Yeah, I mean, we all have to agree. You may be buying, just as the caller that called in, the pig in the poke. If you have knowledge that there was prior activity at the site that could have contaminated the property, but you don't have any further information. So generally, what happens is you negotiate with the seller for a more invasive peek at the property. It's not something that is usually very expensive, but it's called a phase two. And at that point in time, you may pull some soil samples. You may punch a couple of holes to try to get some information subsurface and the like. And either the buyer or the seller can conduct this. A lot of times the seller wants to do it because they want to control what's done. But the problem with that is the seller owns the property. And once they have that information, they may have the duty to disclose. back to the state. So for that reason, even though the seller likes to be in control of what's going on their property, getting that information could be damning, both from the standpoint it may trigger a duty to disclose to TDEC, and then all of a sudden start a full-blown environmental issue at their site that they weren't ready to do because they were trying to sell it and get out of it. Or two, it could then laden them with information that based upon that, if this buyer doesn't buy it, the next buyer, it has to be disclosed to them. And so it will constantly drive down the viability of a sale regarding that property, depending on who the buyer is. So in most cases, better practice is to have the buyer, potential buyer, conduct the investigation, and based upon that information, then determine whether or not they're willing to go forward with either further negotiations, or they may want some further investigation, and you go from there.
So if, let's say, you go through the phase 2, you find some issues that need to be taken care of, some environmental concerns, and the parties negotiate, and the potential buyer purchases the property. Now what do they do? They've got this cleanup that they have to do in order to develop the property, correct?
Well, if a buyer is willing to go forward with a property that is hampered by prior activity at the site, then my biggest suggestion is that they go into what's called the brownfields program, because the brownfield program, or actually it's BOAP, but the brownfields program allows them to redevelop contaminated or hampered. I like to use the word hampered so it doesn't sound so bad, but basically contaminated property, and address the contamination and concerns with the property in the course of development, and get protections. They get protections from TDEC with respect to further regulatory actions regarding the matters. They get protections vis-a-vis third-party claims and adjacent property claims. Those are all the things that can be negotiated or put into a standard brownfield voluntary agreement, BVA, that you would do as part of the acquisition. And, there are a few requirements, and this from working with me on some of these matters. There are a few requirements. Now, what would the law allow the owner of the property that's currently contaminated, allow them to go into brownfields?
If they were the ones that contaminated the property, then no.
Right.
They have to be what they call, I think, an innocent owner.
Right.
Where you're not the one that did the contamination.
Right. That's where the third party coming in is the person who will, once they get this information through a phase 1 and phase 2 of potential prior activity at the site that has caused contaminants, and they've gotten that information. And it may be that the site was a previously industrial site that had its own permits under what's called RECRA for operating. And so they had permits to handle their hazardous waste that was generated in their processes, or they had air issues and the like. But whatever was going on at that prior industrial site, those activities and data is already on file at TDEC. So that's part of your investigation, is you get those documents and see if there have been prior enforcement actions by TDEC or Tennessee Department of Environmental Conservation with respect to that industry and its activities at that property and the like. And you'll get all that data. You'll disclose all that in what's your brownfield petition to be in the program. And once you're allowed to and your petition is accepted by the state with your fee, I think it's a $750 fee that goes with the application. Then what you'll want to do is try to put together a brownfield voluntary agreement, and that BVA, as we call it, can be a living document, because what you're going to do is you're going to disclose everything you know about the site in that agreement, and you're going to disclose how you're going to address the issues that currently exist at the site. But understand that those issues have not yet been addressed, and there may be new information obtained during the course of your activity. And so what you may end up doing is coming back to TDEC and saying, look, in the course of removing this foundry sand, we found some other contaminants subsurface that we need to address that weren't previously known. And so we want to modify our agreement to address these matters so that we get the protections regarding those contaminants and constituents as well.
Now, what if I've been part of the brownfields program, and I've followed my agreement and done those remediations? What if my activities on the property cause further contamination? Am I in trouble for that? Am I liable for that? Or because I was part of the brownfields, am I exempt? I still have that protection.
Well, again, it depends upon what kind of, I mean, if you're saying because of my new business's activities at the site, I've now caused new contamination, then you got absolute responsibility under RECRA as an operator for what the waste that you're discharging that you're not properly containing on your property. So there, it's just like any other industry that's working. Did you have the appropriate permits? Or you appropriately handling your hazardous waste that was generated? Were you properly transporting and disposing of the hazardous waste that was generated in your process? All those issues come into play.
So the brownfields really is for prior activity on the property and remediating those issues.
Now, there have been situations where someone who is working under a brownfield agreement and is in the process of trying to remove contamination may have spread existing contaminants because of just errors. And that doesn't exacerbate your liability or create any liability. It just means that you've got to address what you've just done as part of your agreement because you've now expanded it. For example, you could cause what was basically in situ or in the soil and was stabilized to suddenly get into groundwater, in the course of removal for some reason, because of what was going on subsurface and the geography. So those would then have to be addressed because you now caused contamination to groundwater that was already on site. You didn't create the contamination, but you spread it because of your process.
Okay, so you can address that under your brownfield.
Yes, it requires some amendment and modification, perhaps, of your work plans, but it can be addressed.
Okay.
So, I guess talking to the listener, and as far as, what you want to do is you want to do your due diligence in Chattanooga. I know talking with the representatives of TDEC, there are areas of Chattanooga going on down by Tennessee Temple and the like, which is by and large residential property where they have found foundry sand. That's something I talked about in the first half hour, where they found foundry sand on residential property because nobody knew years ago in those old neighborhoods that the sand was metal laden and was going to cause issues. And so what they do is they go get foundry sand as fill dirt, where they were trying to level out an area on their property, or they were trying to use it to level out so they could build a residence. And so suddenly we've got foundry sand where it wasn't generated, shouldn't be, but it is simply because of past practices.
So what difference is there for a residential purchaser versus a commercial purchaser? Are there any duties of I know that there are disclosures that any seller has to make with respect to residential property, but do you have to do a phase one or anything like that when you're buying a house?
No. And, I think your disclosures under a residential sale, if you're a homeowner and want to sell a home, would be disclosures of matters known. You don't have a duty to do an investigation because your assumption is that the original owner of the home would have disclosed things. And, if you're talking about a very, very old home, something that goes back to the 40s or 50s, I think a buyer of that home may want to do some further investigation than simply a residential disclosure just because of the age of what they're buying.
Mm-hmm.
But no, you would not do a phase 1 or a phase 2 on a residential property.
Okay.
So, but and this is happening all over Chattanooga right now. We're seeing the redevelopment, like we talked about earlier, with the property down in what's called the Gateway. As you're coming around Moccasin Bend on I-24, and you see where U.S. Pipe and Wheeling Foundries used to sit, and that large tract of land that we're looking at redeveloping and studying. We're also looking at developments way down in the south side, areas that, we've built an elementary school down there now, and we're doing all the development in the areas that used to be traditionally, while some part of it was urban residential, a lot of it was industrial, light industrial in some of that area. But because of that, it's required that we do some investigation of prior uses. And again, there are so many sources for this information. I mentioned to you earlier, TVA has flyovers where you can go and you can access photographs of a potential property. And I know the first time I ran into flyovers was back in the early 80s, where I was representing the owner of a commercial industrial site. And we were arguing with regulators that we weren't stacking drums in the areas that they said, and they brought out photographs from the past 5 years showing that we were stacking drums in areas they said. So that's how I learned very well about the use of flyovers and their existence. So that's the information that's available to all the public, and you can get that kind of information. You can also get information from tax records and from business records. Certainly, if there's been a business application that's been filed using the same address as the property you're looking at, and here right now maybe it's just a single family home, but like I said, back in the 30s, 40s, or 50s, it could have been a filling station. It could have been anything. And that's where you run into a lot of issues, because remember the knowledge at the time. Not only did you have petroleum overspill and petroleum leaks of underground storage tanks, which is standard, and we still have those today, but you also had hydraulic lifts, and the hydraulics would leak. And so you got where any hydraulic lifts were and the leak coming from that oil. You also had standard car repairs, and people use degreasers or use paint removers and like to clean carburetors, something you don't see anymore.
So there really were a lot of sources for contamination.
Yes, and those things, somebody would take a pan where they just cleaned and degreased maybe a carburetor, or even just clean their hands, and they pour gasoline over their hands, get paint off their hands, and they go into a pan and they throw the pan out the back door, or dump the pan out the back door, thinking, well, that'll evaporate. Well, they didn't understand that yes, it's volatile because it's petroleum. And so, a lot of that did go into the air, but a lot of it went into the soil. And so as a result of that, there are a lot of sources that can cause contaminants that need to be looked into.
So if I've entered into a brownfields agreement with the state and I've taken care of all the contamination that we can find, that we know of, what happens when we've completed our remediation efforts?
Okay. Well, at that point in time, what you've done is you've fulfilled your contract, because the BVA is basically a contract with the state that we will address these known items based upon this investigation, and we will do these things. And in return for that, we get released from liabilities and protect our liability protections from third parties and the like. You do not get a release from everything because you only get the protections that are addressed in the agreement. So basically, you get a no further action letter saying, okay, you've complied. There's no further action required under the BVA or the Brownfield Voluntary Agreement. And so at this point in time, you qualify for what's there, and you'll have the protections if a third party claims that you've done something to their property because of these activities. But if there's new contaminants found, new information found, if action levels because of further science, because science changes. Remember, that's one of the things that that's why the people in the 60s and early 70s didn't address these issues, because they weren't aware of what the contaminants were doing.
Mm-hmm.
That's why PCB-laden oil was used on streets. Like that same thing.
Right.
We didn't know they were carcinogens. So if the science changes so that the action levels by law may change, then you may need to address some of those things.
Okay.
Well, we're to another end of an edition of Legal Bytes, and it's been a very interesting topic for us today. I've enjoyed the calls, and Katie, thank you for joining us, and I guess we will speak to all of you listeners next Wednesday, where Legal Bytes will come on again at 11 o'clock a.m. Thank you for joining us.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
Your marriage is over. You've been abandoned, betrayed. You're angry, shattered, and heartbroken. Don't go it alone. When you are facing divorce, you need an experienced advocate to help protect your rights and future. And you need it from a man with a sympathetic heart, but a hard nose. Attorney Clay Whitaker will fight for you in this most confusing and bitter time in your life. Clay Whitaker, 756-6400.
Hi, this is Chrissy.
And this is Summer
of Summer Cares. There are too many homeless veterans in Chattanooga. Please help us in our Shoebox for Veterans campaign. You can fill a shoebox with hand warmers, hand sanitizers, hand wipes, cough drops, razors, shaving cream, toothbrush, toothpaste, soap, shampoo,